A very warm welcome to all. Today, I, Reeya Khanna, an intern under LEXIS and Company, am here to share my views on can the Constitution of India be amended or not. Amendment basically means to amend or to edit. The Indian Constitution makers at the time of framing and inserting drafted a very important feature in the Indian Constitution, which makes it a living document. This feature is insertion of the Article 368. The Constitution was made flexible in terms of its amendment, as they believed what is of relevance today may not be of relevance tomorrow. This feature allows the Indian Parliament to amend, to edit, to add, or to repeal any law for the betterment of the country. At the same time, this provision of Article 368 stopped the Parliament from excessive amendments by making the procedure very hard. Pandit Jawaharlal Nehru said, I quote, "We want the Constitution as a solid and permanent, but there is no permanence. If it is made rigid or permanent, it will hamper and stop the nation's growth. Whereas if we make it too rigid, it changes, adopt nothing. However, what we may do today may not be wholly applicable tomorrow." Unquote. Let us understand what is Article 368 of the Constitution of India. The procedure for amendment. A bill is introduced in either of the houses. It has to be passed by each house, either through simple majority or special majority or by ratification, which is then presented for the President's assent. It also gives three types of amendments. Amendment by simple majority is when at the time of passing the ordinary law. Amendment by special majority is when at the time of passing there is total membership of each house and majority of not less than 2/3 the members of that house present and voting. And amendment by special majority and ratification by the legislatures of the state is when there is passing of the bill by special majority and ratification of half of the state legislature. Now, let us view Supreme Court's view on Article 368 of the Constitution of India. The Supreme Court, through various landmark judgments, has given various assenting and dissenting opinion with regard to the matter of amendment of fundamental rights by the Act of Parliament. The very first case was Shankari Prasad versus Union of India, All India Rank 1951. This was the very first case which sparked the debate of amendment of fundamental rights by the Act of Parliament. In this case, the validity of the first Constitutional Amendment Act was challenged. The First Amendment Act inserted Article 31A and Article 31B to the Constitution of India, which violated Article 13 Clause 2 rights vested in the Part 3 of the Constitution of India. Article 13 Clause 2 states that the state shall not make any law which takes away or abridges the right conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. Thus, the petitioner argued that Article 31A and Article 31B should be held void. What the Supreme Court held in this judgment is that the court rejected the above argument of the petitioner. It stated that Article 368 has the power to amend the entire Constitution, and thus the entire Constitution includes the fundamental rights as well. Further, they concluded that the word law in Article 13 Clause 8 includes only ordinary law made by legislative power and not constitutional amendments made by using the constitutional power. Therefore, the constitutional amendment is valid, even if it abridges or takes away the fundamental rights. The very next case in this particular issue is of Sajjan Singh versus State of Rajasthan, All India Record 1965. In this case, the validity of the 17th Amendment Act was challenged. The Supreme Court followed the judgment of Shankari Prasad versus Union of India and held that the word amendment of the Constitution means amendment of all the provisions of the Constitution. Gajendra Gadkar, Chief Justice, stated that If the constitutional makers wanted to separate the fundamental rights from being amendment, then they would have made a very clear provision on this behalf. The very third and the next case is ICE Golaknath versus State of Punjab, All India Record 1971. Now, this particular case and other cases we will understand in the next video. Thank you.